All right, we are ready to proceed. Who are the parties on Ashley Marie Castro?
Hunter Morris, Judge.
I'm Wendy McClellan for the defense.
Let me set us up. All right, the court is calling 2021 CR 7018, State of Texas versus Ashley Marie Castro. Could I have parties announced for the record for the state,
Hunter Morris.
for the defense?
Wendy McClellan.
And are you Miss Castro? I need you to unmute.
Yes, ma'am.
All right, we're proceeding by video because of the pandemic. Any objection from the state?
None, Judge.
Any objections from the defense?
No, Your Honor.
Ms. Castro, I'm showing you what's entitled Defendants Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Defense, I'm showing you what's entitled Acknowledgement of Discovery. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Castro, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Sitting on a lesser included offense of attempted harassment of a public servant, Judge.
Any objections?
No objection.
We're gonna off the record for a moment. Mr. Woods, you're here on struggling.
Good.
Right, I'm gonna send you to breakout room number 2, and one of the prosecutors will meet you there.
Great, thanks, Judge.
You're welcome.
Judge,
And
we,
to the-
we don't need to go into a breakout room. We spoke about this one yesterday.
Okay, then Ted Wood. Well, Mr. Martin, if you go to number 2 and have Ted Wood come out of the breakout room, and I'll take care of that after this hearing.
Okay.
Thank you. All right, Brenna, we are back on the record. Ms. Castro, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of attempted harassment of public servant, that the state jail felony, the range of punishment is anywhere from 180 days to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
All right, off the record. Mr. Gomez, I need you to go to breakout room number 1 to be sworn in, please. And Mr. Seeloff, if you can go to breakout room number 1 to make sure that the clerks have all the paperwork. All right, we're back on the record. Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Castro, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of attempted harassment of a public servant. They're asking that your punishment be assessed at 6 months in the Bexar County Jail under 12.44 of the Penal Code. There are no applications, and there's to be no contact with Cody, C-O-D-I-E, Robledo. Did you understand that to be the plea bargain agreement, Ms. Castro?
Yes, ma'am.
And did you understand that you still will have a state jail felony conviction even though you will receive misdemeanor punishment?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then Ms. Castro, to the lesser included offense of attempted harassment of a public servant, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence support the defendant's no contest plea?
State offers stage 1 and attachments, Judge.
Any
No
objections?
objection. No objection.
Ms. Castro, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same.
Yes.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence. Find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, we just ask that you follow the plea bargain and satisfy the judgment for the time that she has served.
All right, Ms. Castro, what happened on this day?
I know I was in custody at the time, and I was taken out of a holding cell before the certs had detained me in handcuffs and put me against the wall, and that's when everything had happened.
Well, I mean, here's the thing. I know you say that's when everything had happened,
Sorry.
but it's like something happened and actions were taken, right? It just didn't
Yes,
materialize.
I felt like I was provoked at the time before I was taken out of the cell, the holding cell that I was in with another officer. And then at that time I was placed against the wall. I was told to shut up in a different way. I was actually told, they were cursing at me to shut the F up. And that's when everything kind of got out of hand after that. So it just escalated after that.
All right, do you have any children?
No, ma'am, I do not.
How old are you?
I just turned 29.
All right, the court will follow your agreement, sentence you to 6 months in the Bexar County Jail under 1244 of the Penal Code. There's to be no contact with Cody Robledo. Give you credit for any time served. Is this a judgment satisfied?
My understanding, Judge, that she does have the credit to satisfy 6 months.
All right, the court will find that the judgment is satisfied. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Right, and because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, Ms. Castro, good luck to you. Make better choices, okay?
Yes, ma'am, I will.
All right, I have a question before you go. Brenda knows I'm gonna ask this. We can go off the record. You probably know I'm gonna ask you too. So the tattoo above the eye, was that painful?
No, it's not.
Oh my gosh.
There's a reason why I got it actually, but it did not hurt.
All right, see, here's the thing, Ms. McClellan, every male defendant who's had a tattoo above his eye has said it was painful. So,
I
I'm
believe
just
that.
wondering.
I believe women are more pain tolerant, especially because they give childbirth.
Well, question answered. Thank you. All right. Have a great rest of your day. Good luck to you. They'll probably release you from the Bexar County Jail, probably midnight, but you should be released sometime today or either at midnight.
Thank you. Thank you.
Good luck, Ashley.
Thank you.
All right, Norma, can you let them know that L29 can go back?
Yes, ma'am.
Thanks. All right, Joseph Payne. Who is the attorney on Joseph Payne?
Jeb Block, Your Honor.
Who is the prosecutor?
David Martin.
David Martin, can you show your video, please? Or Joe Ray?
I can step in, Judge.
Thank you. All right, the court is calling 2021 CR 7231, State of Texas versus Joseph. Is your middle name Kay or Kai? You're muted.
It's Kai.
Right. Joseph
Yes, ma'am.
Kai Payne. Could I have parties announced for the record for the state,
Joe Ray Garcia.
for the defense?
Jeb Block for Mr. Payne.
And are
Joey,
you Mr.
I can
Payne?
take it.
Okay.
And are you Mr. Payne?
Yes, yes, Your Honor. Yes, I am.
All right, and standing in for the state is David Martin. We're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Mr. Payne, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Judge. I went over it. I signed it. Yes, ma'am.
The court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am. Yes, Judge, I did. I reviewed it and signed it.
Counsel, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Payne, I'm going to show you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am, I did. I
Counsel,
understand.
do you weigh the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are only going to proceed on count 3 and we'll waive counts 1 and 2.
Any objections?
No objection, Your Honor.
Mr. Payne, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, yes, Judge, I reviewed it and signed it. Yes, ma'am.
Did you understand what you're charged with is continuous violence, family? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Judge, I do understand that.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Judge, I understand.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Judge, I understand.
Did you understand by entering this plea bargain agreement, you are giving up those rights?
Yes, Judge, I understand.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Judge, I do.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, I understand, Judge.
Counsel, has your client been able to provide you with any defenses to this offense?
We discussed possible defenses, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Payne, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, no,
Has
Your Honor.
anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Judge, they haven't.
Are you satisfied with the way you've been represented?
Yes, I'm very satisfied.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Judge, I did. I
According
understand
to
it.
the plea bargain agreement, state is proceeding on count 3, waiving counts 1 and 2. State recommends deferred adjudication. There's restitution to Brittany, B-R-I-T-T-A-N-Y, Guerrero, the BIPP force, anger management, $100 to an approved family violence center under Code of Criminal Procedure 42A.504. Do you also understand that the court finds that there is an affirmative finding of family violence? With an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Did you understand that?
Yes, yes, Judge, I understand that.
And did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the entirety of the plea bargain agreement?
Yes,
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm going to show you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
yes, Judge, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I understand.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm going to show you outside the plea bargain agreement. The state is recommending that your deferred adjudication be for a term of 4 years and there be no contact with Brittany Guerrero. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Judge, I understand.
Then to count 3 in the indictment, how do you plead? Guilty, not guilty, or no contest?
Pleading no contest.
State, any evidence to support the defendant's plea?
Yes, Judge. We offer states one in the attachments. I also do want to point out that during lunch, Ms. Guerrero did contact our office and she's requesting a no harmful contact order.
All right. All right, and the court will hear arguments on that. All right, any objections to the state's evidence?
No objection, Your Honor.
Mr. Payne, I'm going to show you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Judge, I did. I signed
Again,
it.
did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Judge, I did.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am, I understand.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, we're back on the record. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
We would like to proceed with sentencing today, Judge.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor, we're hoping you will follow the plea agreement. We're also in agreement with the recommendation below the line that supervision be assessed at 4 years deferred adjudication. We're also in agreement with the request for no harmful or injurious contact with Ms. Guerrero. They do share.
I'm sorry to interrupt, but here's my question. Is the state in agreement with no harmful or injurious contact, or they're just telling me that the complainant wants no harmful or injurious contact?
We'll be okay with that, Judge. They have a 6-year-old child, I believe, that she wants to co-parent with him. So.
Okay.
They have 2 children together, Judge. And I know no harmful injurious contact will make things much easier. He has been, just finally, Judge, he's been in the Bexar County Jail for the last few months and has had a considerable amount of time to reflect on things. And it sounds like he has a good perspective on his future. And I know he has some goals and has written out some things that he has planned for himself and would like to change.
All right, so here's my concern. My concern is I'm reading the police report and the police are called because he comes over to the location. And the complainant in the case, when the police get there, she says, he's not supposed to be here because he previously assaulted her and there's supposed to be a protective order in place. So it appears to me that if I were to allow him to have contact, there's going to be confusion. Because it seems at this time in this report, she did not want him there. She says he still had a key, that she locked the door, but she put the bolt on it. And that I guess he came through an unlocked window that is beside the front door. And he entered the living room and seeing victim 3 pushed her out of the way and began to strike victim 3 in the face and with closed fist. She attempted to stop him from assaulting victim 3 and pleaded for him to stop. So I have a concern with somebody who assaulted someone previously and then comes to the location, the door is bolted. I'm assuming, maybe I'm wrong, but I'm assuming he knew he wasn't supposed to be there and he climbs through a window. So I don't see why there should be contact.
Well, his concern at the time, Judge, was that there was this man that he didn't know in there with his kids. And that was a big reason for him going in there.
Was it really that, or was the concern the fact that this is his girlfriend, the mother of his children, and she's with another guy?
It could have been that too.
I mean, so I don't understand why I should do a no harmful or injurious contact when this is the second time he's alleged to have, well, not alleged, I found that there was sufficient evidence, but this is the second time he's been violent with her.
Well, it sounds like that she wants to have contact with him, Judge, and it's going to be tough for him to comply with the court's order if she's trying to have contact with him to co-parent their kids, but he's not allowed to.
I mean, they have to do the parenting through a third party. I don't feel comfortable allowing him to have contact with her until he's at least started the BIP classes. Everyone is great when they're at the Bexar County Jail. They've learned their lesson, they reflect. But then when they get out and about, there's some argument. And there's an argument because I guarantee you when he gets out, everything's great now when you're at the Bexar County Jail. People can say, I can do probation for life. But then when it starts hitting you, the fact that I'm on probation, I have bills to pay, but yet I got to pay my probation fees, that causes tempers to run high. But so I'm going to do a no contact. But if he has taken at least a month, been on probation for a month, with the BIP course and been in there for a month and everything is fine, I'll reconsider. But I just don't want to send him out there and having contact with her and then everything blows up. So, Mr. Payne,
Yes, ma'am.
once you get enrolled in the BIPP course, if you're in that course for a month, your attorney comes back and asks me to reconsider, I will strongly reconsider allowing you to have just no harmful or injurious contact. You understand?
Yes, Judge, I understand.
All right. Is there anything else, defense?
No, Your Honor, thank you very much.
All right. Mr. Payne, are you going to have a place to work?
Yes, ma'am. I'm gonna have a place to go to work.
And where are you going to be staying? Not the physical address. Do you have some place to stay?
Yes, ma'am. I have a cousin. I have a cousin that I'm gonna go stay with. That I talked to them and they're okay with me coming to stay there for a little while, so I'm able to get on my feet.
Okay. And just do what you're supposed to do, Mr. Payne, and I will consider lifting that, okay?
Yes, ma'am. Thank you so much, Ms. Boyd. Thank you.
Oh, you're welcome. All right, so this is what I'm going to do. 4 years deferred adjudication, proof of employment within 30 days of release. There should be no employment as a home health care provider with minors, affirmative finding of family violence, the BIPP course, parenting classes. Do you want BIPP in anger management, state, defense?
We only want BIPP, Judge.
Yeah, I would assume there's some anger management wrapped into the BIP, but I mean, we'll leave that up to the court, I guess.
All right, so we'll just do the BIPP course. Mr. Payne, honestly, the way to be successful on probation is communication. If you feel you need more to address whatever has caused you to be angry and lash out at people, then just let probation know and they'll help you, all right?
Yes, thank you so much, Judge.
All right, $100 to Family Violence Center, 100 hours of community service restitution. I'll deduct 40 hours if you obtain the COVID vaccine. If you've already had it and you show proof, 40 hours will be deducted. However, I'm not forcing you to do that. Whether or not you do that is completely up to you. It's just if you do it and you've already done it, you'll get a 40-hour credit. You understand?
Yes, Judge, I understand.
Are you able to Zoom?
Yeah, I have an iPhone, so I can do that.
All right, we'll do regular Zoom reporting. If something happens with your Zoom, then you'll have to report in person. There should be no contact with Brittany Guerrero. Are there any drug issues, Mr. Payne?
No, ma'am, I don't have any drug issues or drug habits.
All right, we'll do regular UAs or either the patch. The patch is more expensive, but with the patch, you have more freedom because they put it on you and then they see you probably in a month or 3 weeks. With the regular UAs, you have to come in depending on when they tell you to, and sometimes it's a little inconvenient. Is there anything else you need, Mr. Payne, from the court in order to be successful?
No, ma'am. I think that the class is going to be good, and I think I've got all the help that I need and support from family as well.
All right, and then of course there'll be restitution to Brittany Guerrero, if any. Next, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am, I understand.
And because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Judge, I understand.
All right, with that, I'm going to close the record. Mr. Payne, good luck to you. Mr. Locke, I have one more plea to take up that will require probation. If you can stay in the breakout with your client until probation comes in, because I need them to hear what I'm going to order in this next case.
Okay, Judge.
All right, so yes.
Oh, no, I was just saying thank you, Judge.
Oh, you're so welcome. Thank you.
God
I
bless.
appreciate that. Oh, thank you. I love blessings. God bless you too. I'm going to send you to breakout room number 3, and Mr. Locke, if you could go to 3. And who are the people on John Eddie Macias?
I am, Your Honor.
All right, and I believe that's you, Mr. Seelaw. You're on mute.
I'm sorry, James Seeloff for the defense.
All right, let me get Mr. Gomez here.
Judge,
All right,
before
the
you go-
court is calling 2021 CR 1908, State of Texas versus John Eddie Gomez. Can I have parties announced for the record for the state,
Meredith McIntyre for the state.
for the defense?
James Seeloff, I believe that's Macias is his last name.
Okay,
Thank you.
you're welcome. And are you John Eddie Gomez Macias?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Mr. Macias, I'm going to show you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you
Yes.
understand it? And did you electronically sign it?
Yes, ma'am.
All right, just one moment, please. Ms. Boyd, I'm going to send you to a breakout room.
Okay.
Everyone, she's here on Wendy Rathburn. It appears to be Criminal Trial Division. I'll send you to breakout room number 4. All right, the court will find that defendant has knowingly and voluntarily consented to appear by video. Next, Mr. Macias, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Macias, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We waived the reading.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Macias, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, I did, Your Honor.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, a right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
I want to.
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he was.
Mr. Macias, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, I did, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the state jail facility. There's a $1,000 fine to be probated. There's no application for deferred adjudication. The state recommends community supervision. There's to be no contact with detailing team at 6803 IH 35 South, and the state will not pursue charges on the SAPD 2113741. Did you understand that to be the agreement, Mr. Gomez? I'm sorry, Mr. Gomez Macias.
Yes, Your Honor. I I did.
Defense, is that the agreement?
That's our agreement.
State, is that the agreement?
I believe there's also restitution on there, Judge.
Oh, I'm so sorry. Thank you. There is restitution of $2,800 to auto detailing team Moses Soto. Did you understand that to be part of the plea bargain agreement, Mr. Macias?
Yes, I did, Your Honor.
Defense, is that the plea bargain agreement?
Yes,
From this
that's the
point
full
on.
plea bargain.
So I
Yes,
just wasted 45
All right,
days.
just one moment. Yes, to the manager who's listed,
Okay.
I'm going to send you to a breakout room with the court coordinator. I'll send you to breakout room number 1. All right. We're back on the record.
thank you.
Mr. Macias, I'm going to show you what's entitled Waiver of Appeal. Did you review that document with your attorney?
Okay.
Did you understand it?
Normally.
Yes, I did, Your Honor.
Did you electronically sign it in both places?
Yes, I did, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I did.
Counsel, have there been any such motions?
No motions, Your Honor.
Well, yeah.
Next, I'm going to show you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 80 hours of community service restitution, regular UAs, and the felony theft course. Did you understand those recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's guilty plea.
State offers State's Exhibit 1 and all attachments.
No objection, Your Honor.
All right, Mr. Macias, I'm going to show you what's entitled. Well, there's a lot of
Okay,
ones.
thank you.
I'm so sorry. The court is going to show you what's entitled Waiver and Consent to Stipulation of Testimonies and Stipulation. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
He's on mute.
Yes, Your Honor.
Again,
Thank
did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, I asked the court to waive. PSI.
Anything you wish to say on behalf of your client?
Yes, Your Honor. He's approximately 30 years old. He's a court-appointed client, and he's already has to pay part of his probation, $2,800 restitution. I asked the court to keep that into consideration on those additional matters that Ms. Meredith brought up. Thank you very much.
Thank you. All right, Mr. Gomez, can you unmute for me, please?
Ma'am,
How old are you?
I'm 31.
All right, do you have any children?
No, ma'am.
All right, when did you start using drugs?
When I was 21.
And why did you start using?
Just I guess around bad neighborhood, around bad people.
Well, everybody's and not everybody, but many people are in bad neighborhoods.
Yeah.
And when
I understand.
anybody comes before me and they say that they were around bad people, the bad people that you say you're around, if they were in your shoes, they would say, I was around bad people. And I would say, well, who's the bad people you were around? And you know what they'd say? John Eddie Gomez Macias, right?
Yes, ma'am.
So how are you planning on changing your life?
Well, I have a good, I have my cousin out there that I had talked to when I first came in, and he was willing to, let me go to work with him. And that's, Joe Lopez, landscaping.
Mhm.
And I've done it before with him before when I was a lot younger. And, well, like I got into the drugs and stuff like that, and well, I have stopped. And, now I talked to him again because he's like a long distance cousin.
Mhm.
And I talked to him again, and he's willing to let me back.
When's the last time you used? And I say last time you used, I mean, before you went into custody.
So I went into custody. Like a month before I went into custody.
Okay. And how often were you using before you went into custody?
Not much at all. Maybe. Like
Here's
a
the
gram.
thing, Mr. Macias, you need to be honest with me. And let me just tell you why. Because I'm trying to help you. Your attorney's trying to help you. The state offered you probation. They're trying to help you. So right now, where you are, everyone is trying to help you. They're trying to make sure you become clean and sober and not become a statistic, which means not ending up in prison or not dying, because I guarantee you the people who make these products, one, they're not FDA approved, and two, they really don't care about what's in the product, right?
Yes, ma'am, I know.
So how often were you using?
Like I was using it every day.
Okay. See, that wasn't hard. That's the first step, right? First step is, and it's the first step, I know it's always the hardest, it's admitting it. But life is a journey, and where you are right now doesn't mean that's like the pinnacle of your journey. We're all on life's journey, we're all learning things and trying to do better. Okay?
Yes, ma'am.
All right, they're gonna ask you to do a felony theft course. I could do a felony theft course in less than 2 minutes, but nobody's given me a grant for my course. So here's my theft course. Don't take what doesn't belong to you. Don't go into any building or any home unless you're invited. And when you're asked to leave, leave. That's my felony theft course. But I think they have one, I guess that's more in tune to maybe what you need. So I'll do the felony theft course. All right, so 2 years in the state jail facility, suspended and probated for 2 years, $1,000 fine, that will be probated. Restitution of $2,800 to auto detailing team. I guess the owner is Moses Soto. No contact with auto detailing at 6803 IH 35 South. State will not pursue any charges in SAPD 211-37401. 80 hours of community service restitution. 40 of those hours will be waived if you decide to take the COVID vaccine, or if you've already had it and you present proof of that. 40 hours will be deducted. I'm not ordering you to do the COVID vaccine. That is completely up to you. You understand?
Yes, ma'am.
The felony theft course, how far did you go in school?
To the 10th grade.
Okay, why did you drop out at the 10th grade?
I guess I was missing more days than what I attended. That's why I think they didn't want me there no more, and I didn't bother to go to any charter schools or anything. I just dropped out.
Okay, I'm going to waive the remaining community service restitution hours if he obtains his GED or applies and is accepted and completes some sort of trade school. You got to do something with your life. Lawn work only pays so much, like maybe $40 a yard. I'm going to do regular reporting by Zoom. I'm going to refer him to felony drug court. That's to be done while he's in custody. Mr. Macias, felony drug court is very quick. So you'll probably be seen by them no later than Tuesday. You understand?
Yes, ma'am.
If he's not accepted to felony drug court, then I'm going to want intensive outpatient treatment with probation and the UA hotline. and random field visits 3 times per month. Mr. Macias, felony drug court should accept you if you're honest with them. They can help you. They can help you with a place to stay. They can help you with employment. They can help you with your schooling. You understand?
Yes, ma'am.
And I'm sorry, if you're released, are you able to report by Zoom?
Yes, ma'am.
All right, so if something happens and you can't report by Zoom, it needs to be in person. But Kevin, he's going to remain in custody until he's accepted to felony drug court. Mr. Macias, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Macias, good luck to you. Be honest with felony drug court, okay?
Okay, ma'am.
All right,
Thank
good
you.
luck to you. I'm going to
You're
send you to break up. Yes.
Okay, I was gonna ask you, you're gonna send him to probation officer to talk over the terms?
Yes, I'm going to send him to breakout room number 3. Mr. Seeloff, you can go to number 3 or you can be excused. And Kevin, you can go to number 3 now.
Okay, I'd like to be excused, Your Honor. Good luck, John.
All right, thank you.
All right, thank you. You're excused, Mr. Seeloff.
Thank you, Your Honor. Thank
You're welcome.
you for your patience today.
Oh, thank you so much for your patience.
Stay safe.
You
Thank
too.
you.
Badgers can't lose Saturday.
Okay, we'll see what happens. See if people are upset or happy on Monday.
Well, they don't play. They play the following week against Notre Dame. Hello? I guess we need practice time.
Okay,
Thank you, Judge.
you're welcome. All right, who are the parties on John Rice?
Eduardo Jimenez here for John Rice, Your Honor.
All right, and who is the prosecutor?
I believe it was Marcus Sanders, Your Honor.
All right, the court is calling 2021 CR 6034, State of Texas versus John Rice. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Eduardo Jimenez.
And are you Mr. Rice? Could you unmute for me, please?
Yes, ma'am.
All right, we're proceeding by video because of the pandemic. Any objections from the state?
None.
Any objections from the defense?
None, Your Honor.
Mr. Rice, I'm going to show you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Defense, I'm showing you what's entitled Acknowledgement of Discovery. Have you received all the discovery in this case? Did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Rice, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, we're proceeding on count 2, waiving count 1.
Any objection?
No objection, Your Honor.
Mr. Rice, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am. I wasn't there for my kid.
Did you understand that what you're charged with is aggravated robbery? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am. Open up my eyes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do, Judge.
Mr. Rice, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you what's entitled plea bargain agreement. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count 2. Punishment is to be assessed at 5 years in the prison. There's an affirmative finding of deadly weapon. There are no applications. The state asks that this run concurrent with 659165. The state will take in consideration grand jury number 743254. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
That's correct, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm going to show you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, there have not.
Then to count 2 in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, the state offers States Exhibit 1 and its attachments.
Any objections?
No objection, Your Honor.
Mr. Rice, I'm going to show you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented and waived and consented to stipulation of testimony and stipulations. The court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty as charged in count 2. Are you proceeding with sentencing?
Yes, we are, Judge.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right, the court will follow your agreement, sentence you to 5 years in prison, give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with 659165. Taking consideration grand jury number 743254. Next, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, Mr. Rice, good luck to you. We'll go off the record. Mr. Rice, you got to change your ways. Otherwise, it's not going to end well. You understand?
Yes, ma'am.
All right, good luck to you, Mr. Rice.
Yes, ma'am. Thank you.
You're welcome. Norma, you can let them know that 14B can go back. And Mr. Jimenez, you're excused.
Thank you so much, Judge.
You're welcome. All right, are we ready on Mr. Stribling? And Lisa Voigt, do you need to speak with your client?
I do for a second, Your Honor, but we're going to need a reset on this case because the state needs to do a little bit more investigation before they're able to give an offer today.
All right, Norma, on Rathbone, can I have a 30-day reset, please?
October 21st, Judge.
All right, October 21st. Ms. Rathbone, you can go to a breakout room with your attorney. And Ms. Voigt, she's in number 5, but I need you to have her come out of breakout room number 5 when you completed speaking with her.
Okay, thank you.
You're welcome. All right, who is the attorney on Stribling? Is the attorney ready to go on Stribling? The state's attorney.
It's a family case, Judge, but Hunter can step in.
I can step in, Judge. I believe David had to log out.
Okay, all right, let me have you step in, and then we have Williams Alexander with Alfonso Cabanas,
Yes, Your Honor. I'm present for Mr. Williams.
and it's criminal trial division. So
That's
I'll send
correct,
you to
Judge.
breakout room number 2.
Yes, Your Honor.
And then after this, we'll take up the other matter that's involving Kevin Hagerling. My understanding, Kevin Hagerling, that's been worked out.
Yes, Your Honor, we have an agreement, somewhat of an agreement on a cap, so.
All right, has paperwork been done?
No.
All right, so I'm gonna send you and your client to breakout room number 1.
Okay, perfect.
I don't see Hagerling on the screen. Let me find him.
I think he might be in a breakout room, Your Honor, and I got kicked out, and so I have no idea what room.
All right, I'll send you to number 1. And if you could type into the chat box to Ms. Ferguson what the agreement is, and she'll get the paperwork to you.
I will do it right now before I join the room. Okay, perfect.
Thank you. And to the parties who are waiting to be witnesses on that, if you could please remain. And Ted Wood, before we go on the record, which case are we going on with you?
Well, Judge, this is a bond hearing. So we had an agreement on the dope case.
So
bond-
is it 20, because the motion I have is 2021 CR 6625. Is there another one?
Yes. Well, Judge, the affidavit of surety to surrender was filed by the bond company on the drug case. And Mr. Martin and I agreed that he would not oppose setting the drug case to $10,000.
Okay. I'm sorry, let me just find that.
No problem, Judge.
Okay, so 2020 CR 2491, there's an agreement to $10,000.
Yes, Judge, that's correct.
To the clerks, could I have the B page on 2020 CR 2491, please? All right, and then on the 2021 CR 2273, is that a bond issue as well, Mr. Wood?
No, Judge, the bond is in place. Nobody's arguing about it. The bond has been paid, so it's not the subject of this hearing.
Okay. So I'm going to fill out the paperwork on the bond for the drug case. Just give me one moment.
Very well, Judge, thank you.
All right, so now the only issue is the 2021 CR 6625.
Yes, Your Honor.
Okay, and tell me, what is the issue on this one?
Judge, right now, the bond is set at $250,000. And it's my assertion that that essentially constitutes a no bond ruling. I'm asking that the bond be lowered to somewhere around $25,000 to $30,000.
Okay, all right.
With
Now
all
that
the
I,
conditions.
all right. So now, is this the bond where the bondsman got off the bond?
No, Judge, that's the dope case. That's the 2020 CR, I think 2490 or 2491.
Okay, all right. So we're ready then to go on the record. The court is calling 2021 CR 6625, State of Texas versus Matthew Stribling. Can I have parties announced for the record for the state?
Joey Garcia.
For the defense?
Judge Ted Wood for Mr. Stribling.
And are you Mr. Stribling? Could you unmute for me, please?
Yes, ma'am, I am.
All right, we're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Judge.
Mr. Stribling, do you have any objections to this hearing taking place by video?
No, ma'am.
All right, defense has filed a motion for a reduction of bond. State, are you opposed?
Yes, Your Honor. There's
And
no,
state, are you ready to proceed on this motion?
yes, Your Honor.
All right, defense is your motion, so I'll allow you to begin.
Judge, I'd like to call Mr. Stribling.
All right, Mr. Stribling, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am, I do.
All right, you can lower your hand. If you could state your name for the record, please.
My name is Matthew Thomas Stribling.
All right, defense.
Thank you, Judge. Mr. Stribling, before you got incarcerated, how much money were you making?
I was making approximately $700 a week.
And what were your obligations outstanding at that point in your life?
My child support,
How much is your child support?
it's $1,200 a month.
What about your rent?
My rent is $665.
And what about your phone payment?
Phone payment is another $60, $70.
What about your car payment?
I had a vehicle, personal vehicle that was paid off.
Okay. Do you own any valuable coins or paintings?
No, sir.
Do you own any rental property?
No, sir.
Do you own any stocks or bonds?
No, sir.
Do you own any certificates of deposit?
Not that I'm aware of. I don't know if my mom or my grandpa has anything for me. But I know.
Are you a beneficiary of anybody's will or testamentary disposition?
No, sir.
Do you receive money every month from a bank or a financial agency in the form of a judgment?
No.
Okay. Now you understand that the court is going to make a decision today on the violation of a protective order, right?
Yes, sir.
And Mr. Stribling, will you explain to the judge, if she does grant you a bond that you can make, what you will do to ensure that you will go around any of this complaining witnesses, the complaining witness or her mother?
I'd be more than happy to go on GPS monitor. If it needs to be house arrest, then I'd be willing to do house arrest as long as I have the ability to get to work. I'd be working in a warehouse setting, so I wouldn't be out in a truck like I was before. So I'd be in one stationary location with set hours versus what I had before. If it could be tracking just to where I can, do things with my kids, go to the park and stuff like that, which is just down the street from my apartment. There's no park that I would have to go anywhere to any side of town that they're on, which I currently don't know where they're living or what any matters of that. So anything that the court would want me to do, I'd be more than happy to follow those guidelines. And I do understand, and all respect to you, Judge Boyd, I did not mean to not show up for the court proceedings before or not do the GPS monitor. But I mean, I'd be more than willing to follow those guidelines and continue with that, as you stated.
And Mr. Stribling, the most important thing for you to be able to do is to do your work so you could pay your child support, right?
Yes, sir.
And if it made the judge a little bit nervous for you to be at the park with your kids, you'd be willing to forego that, right?
if I needed to be, as long as I could be out, I can watch movies with them. I can make popcorn. We could do s'mores. We could do movie night at the house. We could play games. There's other things that we could do to where I could still be with my kids.
And you're willing to put the payment of the GPS in front of your other commitments?
As long as it was whatever I needed to do, like I stated, as long as the court would be satisfied with whatever they need me to do, I'd be more than happy to do that. So if I got to pay for it, I have to pay for what I got to pay for.
Are you telling this judge that your job where you were out and about all day long in a truck is gonna go the way of history, and you're now gonna be working in a warehouse where you will not be out driving around all day?
Yes, sir.
And so if she were to grant you a bond that you could afford and you went out, your GPS would reflect your home?
My home and my workplace.
And it wouldn't reflect Jimmy John's at lunch with your fellow warehouse workers?
I'd get it delivered.
And it would not reflect the stop and go after work with a case of beer between you and your fellow warehouseman?
No, it'd be a favored delivery and it'd be a soda for me.
Very well. No more questions, Judge, at this time.
All right, State.
Yes, Judge. Mr. Stribling, on
Yes, sir.
11th, 2020, you were charged with attempted arson.
Yes, sir.
You were also charged on that date with aggravated assault with a deadly weapon.
Yes, sir.
And you were also charged on that date of assault family second, correct?
Yes, sir.
And I'm sorry, what was the full date of that, Mr. Garcia?
November 11th, 2020.
Or you can continue.
Okay. And Mr. Stribling, you still had a pending case of possession, right? 1 to 4 grams?
Hold on,
Yes, sir.
hold on. Sorry, Joey,
Oh.
I didn't catch the beginning because there's noise in the background.
Oh, sorry about that. Yes, I just asked, before that, he had a pending case of possession, 1 to 4 grams.
Yes, sir, I did.
Okay. And let's go back to the November 11th, 2020. About 12 days later, on the 23rd, you picked up the repeated violation of protective order, right?
That I'm not aware of. I thought they had stated that it was that I had gone in February or April is when they stated that I went back to her supposed house or apartment.
Okay.
I don't know about on the November 23rd. That I'm not aware of.
So you're not aware that you've been indicted, and one of the dates that on the indictment is on the 23rd of 2020?
I'm aware I'm indicted of the violation of the protective order. I just didn't know the date. Well, I didn't see that the date had 11/23. But if it's on there, then it's on there. And
Okay. And who is the person you weren't supposed to have contact with?
Amanda Sepulveda.
Okay. And is she the same person involved on the March 11th, 2020 case?
That's the dope case, correct?
No, that's the attempted arson and the ag assault.
That's November of 2020.
Yeah, you said November. You said March. I'm sorry.
Excuse me. I mean, I'm sorry, November 11th,
Yes.
2020.
Yes, that's why I got confused. I'm sorry. But yes, no, that is the person.
Okay, so that's the same person that you picked up the violation of protective order?
Yes, sir.
And on the violation of protective order case, your bond is set at $250,000, correct?
Yes, sir.
Are you aware that a grand jury set that amount?
I am now.
That's irrelevance, Judge.
That'll be overruled.
Okay, no further questions, Judge.
All right, defense, any other questions?
Just a couple, Judge.
Yes.
Mr. Stribling,
Yes, sir.
you know this judge holds your freedom in her hands, right?
Yes, sir. And I do know she's a fair judge, and everybody that I've talked to that I've been in this court, they said she's followed her life to give it to law, and she knows everything, and she has the most power to give you anger management. She knows all the classes. She knows everywhere that you can go to get help. So I put my life in her mercy, I guess you could say, because it's up to her and it's her decision. And I want to get help. That's all I want. I just want to get help.
Judge, did you hear him say that you know everything, Judge?
Yes, I heard that.
Very
I
well.
am not all knowing and all seeing.
I've
And
talked
as
to
I
a couple
tell
of
everyone,
deputies.
this is not the minority report. I can't see in the future.
Yes, ma'am.
Sure,
No,
no,
but I've talked to a couple of deputies here and they've given nothing but great reviews about you, you know, and all the help that you've given to other people and stuff like that.
Mr. Stribling, how much money can you afford on a bond on this situation? Violation of protective order.
Honestly, it would be up to my family because I mean, the only thing I have in my bank account right now is $1,000 that I'm supposed to have in my bank account from when I last got paid. So I mean, that would satisfy one of the bonds, and then whatever, if anything, my family could put in. But I mean, if I can, like I said, if I can get out on monitor, and if it'd be a PR bond or anything like that, again, this is all up to the judge, and I don't know if that would even be allowed to be granted, being the type of cases that is.
It's not. So do you have somebody who's willing to help you with your bond?
I'm sorry, yes, I have a.
Take down head shakes.
I'm sorry, I didn't know I was on mute to do it, but yes, I do have a couple people that would be able to help me with bond.
How much money can they put together for the bond?
I would have to contact them to find out. I wouldn't know, but I mean, maybe another 1,000 to 2,000 at the most.
Okay, no more questions, Judge.
All right, anything else from the state?
Just a few, Judge. Mr. Stribling, you stated that you've been on GPS before, right?
No, sir, I've never been on GPS monitors. The judge had ordered tracking, but I had not successfully gone to it to get it done. But I would be more than happy to get on GPS monitor and tracking, house arrest, whatever it may be that I need to be on. So that way the court satisfactory knows that I'm not going around, nor am I having any contact with Ms. Sepulveda or her mom or any of her family or her friends or anything like that, trying to get in contact with her, do anything.
Okay, so it's fair to say that you were given a chance to get that monitor before, right?
Yes, sir, but I was sick, and then I had a work obligation that didn't allow me to get out there and get to it. And then I worked every day. We work 6 days a week, and they're not open on Sundays. But it's still, again, my fault that I did not get on there like the judge had ordered.
Okay, and you also stated to your attorney that you failed to appear in this court before, correct?
Yes, sir. Again, it was just a work obligation, and I was sick on the last time, so I had a staph infection.
Okay, no further questions, Your Honor.
All right, is there anything else from the defense as far as witnesses or testimony?
Thank you.
All right, the court will hear argument, defense.
Judge, the bond set by a grand jury, I think, is very clearly punitive. Maybe they don't really understand the implications of what they do. Mr. Stribling is doing what he needs to, what he can to support his children. I'm asking, Judge, that he be granted a bond that he can actually make and get out and try to work and pay money for both the GPS, for his living expenses, and for his child support. You know, a lot of the dads that we have in our world don't even acknowledge child support payments. He's significantly behind. He's told me that before, and I'm just asking, Judge, that he be given a bond that he can actually afford, which I figure for this offense, because let's be clear, you're thinking it, so I'm just going to go ahead and say it. He picked up a new charge while he was out. Wish it was different. It's not different. So I don't expect it to be low like the drug case or anything, but Judge, I'm asking for a figure that he can actually afford and get out and start to work again and start rebuilding his life.
All right, state.
Judge, I think there is a reason why the grand jury picked such a high bond. He had a pending drug case. He picked up attempted arson, he picked up an ag assault with that, and an assault family second. And just 12 days later, with the same complainant, picked up a repeated violation of protective order. He's also been given a chance on GPS, as he stated. He's also failed to appear. So for the safety of the community, the fact that he's a flight risk, and the safety of the complainant, we ask that the high bond remain.
All right, Mr. Stribling.
Yes, ma'am.
I want you to understand where I'm coming from, all right?
Yes, ma'am.
The purpose of bond are to ensure that somebody appears to court. That's how high it's supposed to be, that if something were to happen, you would lose more than, just not appearing in court. So it's designed to be high enough so that you will appear in court, right? but
Yes,
not
ma'am.
so high that you can't bond out.
Yes, ma'am.
So in your case, you did bond out and you didn't appear. And
Yes,
you
ma'am.
didn't inform the court. You just disappeared. Because what I can tell you on this Zoom screen, if an attorney comes to me and they say, my client is sick, and they provide me proof that they're sick, it's like, I can understand that. If somebody has COVID, if somebody's in the hospital and somebody lets me know, I can understand that communication is key.
Yes, ma'am.
Now, with your cases, I don't take any of these cases as true because no evidence has been presented to me.
Yes,
But
ma'am.
I do have to look at the charges, right?
Yes, ma'am.
And the problem and the concern is that you have the attempted arson and the repeated violation of a court order or bond. You know what the word repeated means? That
Continuously
means that
doing.
it's happening more than once and that somebody's already told you. And part of bond is ensuring that the bond is high enough to protect the community, right?
Yes, ma'am.
So I'm going to deny the defense's motion for a bond reduction, but I wanted you to understand why it was being denied, all right?
Yes, ma'am.
All right, thank you so much, Mr. Stribling. We can go off the record. My understanding, Mr. Wood, if you talk to Ms. Ferguson, she will have, I think, the documents already with regards to Dr. Jumis. So she may have that to send to you, or either Judge Carruthers' court may be sending those documents to you.
Very well, Judge. I've spoken with Dr. Jumis. He told me that he was planning to have his report ready tonight.
Okay.
As they say, vamos a ver, we'll see. Hopefully he will. And Judge, thank you very much for your time and your studied consideration of the arguments that we made.
Of course. And Mr. Wood, do you want your client brought back anytime soon, once you receive the report? Because we can give you a date.
Well, Judge, can we have the informal competency evaluation in your court, or must it be in front of Judge Carruthers?
It has to be in Judge Carruthers because that's where it's originating. And I just want him to continue to keep that. But I will tell you what, I know it's set for October 20th. Is that when it's set, the informal inquiry?
Yes,
I'm
Judge.
sorry, the informal competency.
Yes, Judge.
What we can do then is, if you're able to move it up in that court, if it's something that's going to be agreed to or not agreed to, I don't know what the results are, Mr. Stribling. You can always come back here as soon as that's done or move it up.
Very well, Judge. Very well.
Do you know if it's agreed?
Judge, the competency evaluation will be agreed. I can tell you that now. I don't think Ms. Unkefer is going to argue with the finding, which I anticipate will be competent.
All right. So if it's agreed that he's competent, if you speak with Angela or Judge Carruthers, then yes, I don't mind hearing it.
Okay.
Yes.
Okay.
I thought it was incompetent. So if it's incompetent, I prefer to leave that to Judge Carruthers, because based upon the charges, he would have to be sent to a different facility.
Okay. I'll get in touch with Angela and we'll suss it out.
All right, Mr. Stribling, yes?
Now I know the last time I was here on the 25th, before the incompetency exam was to be it was going to be done the same day, but they had said that I had a partial plea deal of 7 years deferred.
No.
Okay.
I don't want to hear what the agreement is. This is not the proper time for me to hear that.
Okay, I just wanted to know if that would still be
No. That's something you need to speak with your attorney in the state about, but that's not something that I would address at this point in time, okay?
Would I be able to do that today?
You can speak to your attorney, and your attorney can speak to the state.
Okay, thank you, ma'am.
You're welcome.
Again, thank you and God bless.
Oh, thank you. God bless you too.
Yes, ma'am.
Mr. Wood, would you like to speak with the state?
No, Judge, Mr. Martin and I have talked it over. We have a tentative agreement in place that I have a lot of confidence in. So if I could spend a few minutes with Mr. Stribling and be excused from the breakout room.
Well, before you leave, you'll have to have Mr. Stribling come back to the main room.
Okay, we'll do it.
Okay, so Mr. Stribling, I'm going to send you to breakout room number 4.
Yes, ma'am. Thank you.
You're welcome. And let me find you, Ted, if you could go to number 4.
Thank you, Judge.
You're welcome. All right, any of the other parties ready on Hagerling? Do we have the paperwork?
And Judge, I think Mr. Cabanas is ready.
All right, Alfonso Cabanas. Alexander Williams, what is happening?
He wanted a court date and I gave him a court date already.
All right, it appears he's in a breakout room by himself. Let me go to number 2 and have him.
I think,
come back to
Judge,
the
I think he was waiting for us to go in there together to confer on a date.
Okay.
We don't want to interrupt the hearing.
Oh, no problem. You want to go to number 2 then, Hunter, and come back?
Yes, Judge.
All right, thank you. All right, so everyone, I'm just waiting for the paperwork on Hagerling. All right, who are the parties on Hagerling?
Joe Ray for the state judge. It looks like they're still in breakout room 1.
Okay.
And
All right,
speak to her.
okay, let me see if they're coming out of breakout room. I will be right back. Okay. I didn't mean to do that, but it happens. All right, the court is calling 2019 CR 11098, State of Texas versus Kevin Gennaro Hagerling. Can I have the parties announced for the record for the state?
Joe Ray Garcia, and I apologize. I still need to clear up a few things with defense.
Okay, no problem. I'll send you to a breakout room. Let me find Miss Garza. Ms. Garza, if we'll go to breakout room number 2, please.
Right, thank you.
All right. Alfonso Cabanas on Alexander Williams. Y'all were conferring on a date.
Yes, Your Honor, I confer with Hunter and with Norma, and the date that was given to us for trial is December the 9th.
Okay. All right, we will put it on the record. Court is calling 2020 CR 4626 and 2020 CR 5285, State of Texas versus Alexander Williams. Could I have the parties announced for the record for the state?
Hunter Morris.
For the defense?
Alfonso Cabañas for the defendant, Alexander Williams.
And are you Mr. Williams?
Yes, ma'am.
I don't need you to speak up. We're proceeding by video because of the pandemic. Any objection from the state?
None, Judge.
Any objections from the defense?
None from the defense, Your Honor.
Mr. Williams, any objections to us for appearing by video?
No, ma'am.
All right, my understanding is that Mr. Cabanas, you received all the discovery in each of these cases. Is that correct?
Yes, Your Honor, I have all the discovery that the state has provided.
All right, the court does not have an acknowledgement of discovery in its file. State, I'll need the acknowledgement of discovery on this case by October 8th. Is that possible?
Yes, Judge. I would note the main case is an aggravated assault 701 case, but I will get that message along to family violence to make sure. I can't speak for their case and don't know if there's any outstanding discovery.
All right, thank you. Has an offer been tendered?
Yes, Judge.
Yes, Your Honor. To clarify Hunter's position, my understanding is that the state's going to go on the family violence case. So on the family violence case, the state has tendered a plea offer that's been communicated to my client numerous times.
And Mr. Williams, are you rejecting those offers?
I don't know an updated offer, man. I thought I was going to trial today, so I don't know an offer, what he's talking about.
All right, I'll send you to a breakout room to confer with your client,
Yes, Your Honor.
and I'll send you to breakout room number 1. And Mr. Williams, you need to go to breakout room number 1.
And Judge, real quick, what was that date? October what?
October 8th.
I'll just get one sent over real quick.
All right, sure, no problem. Brenda, I'm going to send you a chat.
Okay.
Thank you. Kevin, could I see you in breakout room number 4, please?
Yes, Your Honor.
Oh, not Kevin Hagerling. I meant Kevin, the probation officer.
Kevin, are you done with both inmates?
Yes, you're done.
Okay, thank you.
All right, so Kevin Hernandez, if I could see you in number 4.
Can you switch me? It says 3.
And Norma Gomez is 14M.
Yes, ma'am. Thank you.
All right, are we ready? Or Mr. Williams?
Yes, Your Honor, we're ready.
All right, I'm sorry, just give me one moment. I just had an emergency. All right, we'll be back on the record with Mr. Williams. You need to show your video. All right, so we're back on the record in 2020 CR 5285 and 2020 CR 4626, State of Texas versus Alexander Williams. Mr. Cabanas, has an offer been tendered in each of the cause numbers?
Yes, Your Honor, an offer has been tendered, explained to Mr. Williams, and he's requested a jury trial, Your Honor.
All right, Mr. Williams, are you rejecting both offers?
Yes, ma'am.
And you're requesting a jury trial?
Yes, ma'am.
All right, your jury trial date will be December 9th at 9 a.m. in the 187th District Court. You'll need to appear in court dressed for jury trial at 9 a.m. The courtroom is located at 300 De La Rosa on the 4th floor. Again, it's the 187th District Courtroom. Any objections to that date from the defense?
No objections from the defense, Your Honor.
Any objections from the state?
None from the state judge.
Any objections from you, Mr. Williams?
No, ma'am.
All right, I'm sorry, everyone. Just give me a moment. All right, we're back on the records. I'm sorry about that, everyone. So, Mr. Williams, do you understand when your jury trial date is?
Yes, ma'am.
What date?
December the 9th at 9 a.m. and court 187.
All right, and Mr. Williams, if for any reason juries are still suspended, your attorney will be made aware and he'll tell you how to appear, all right?
Yes, ma'am.
All right, thank you. If there's nothing else, we'll close the record and you're excused.
Thank you, Judge.
You're welcome. All right, we're going to take up Mr. Hagerling. Are we ready on Mr. Hagerling?
No, Your Honor, so the state wants us to plead on another criminal case as well. It'll be concurrent with the MTR. So I'm awaiting the paperwork as we speak. So, and I let Norma know as well.
All right, so then as soon as that paperwork is done, we'll take it up.
Yes, thank you.
All right, you're welcome. Let me send you to a breakout room with your client. Mr. Hagerling, if you can go to breakout room number 2, and we'll get the paperwork done. And Ms. Garza, if you could go to 2, please. And Brenna, I'm going to make you host for a moment.
Okay.
Thank you. And everyone, I'll be right back. Ms. Garza, are you waiting for paperwork? Ms. Garza, are you waiting for paperwork? You're on mute.
I haven't checked yet, Your Honor. I was conferring with my client and he was asking me something and I'm just, I'm chatting with the prosecutor right now. On just clarification on the paperwork. I've gotten enormous plea paperwork, but I still haven't gotten from Joe Ray. And we're conferring, Your Honor.
It'll be there in a few minutes.
And the ADA, Almanzi, are you here on this case as well?
There's a CPS matter involved, so I just wanted to step in and just listen.
Okay, all right, thank you. Well, everyone just give us a moment.
Absolutely.
All right, who's the prosecutor on Hagerling?
Joe Ray, Judge, I'm on the last page. I'm sorry, I had to start the paperwork all over. There was a change in agreement.
All right, thank you. So you know about the other issue?
Can we talk in a breakout room, Judge?
Yes.
Okay.
So I'll see you in breakout room number 1. And Ms. Garza, if you could come to 1, please. And Ms. Ferguson, if you could come to 1. Mr. Hagerling, I'm going to send you to a breakout room with your attorney. I'm going to send you to breakout room number 1.
Hey, Norma, can you allow my client to share his screen?
Ms. Garza, the share screen is on for your client.
Said that it was
Let's go
disabled.
into the breakout room.
Okay, it said it was
You go back
disabled.
to number 1, please. All right, Mr. Hagerling, if you can go back to, well, I tell you, go to breakout room number 2, Mr. Hagerling.
Yes, ma'am.
Thank you. Mr. Hagerling, have you been sworn in? All right, you need to go back to breakout room number 2 to be sworn in.
Okay, okay. Yes, Your Honor.
Or either, I tell you what, to make it easier, I'm just gonna see you.
Okay.
Thank you. Ms. Garza, has your client signed his paperwork and forwarded it? All right, everyone, it appears that we're going to take this up tomorrow. I'm so sorry for any inconvenience, but everyone, we're going to take this up first thing tomorrow morning. Yeah, Norma, on this case, are we able to bring it back first thing in the morning? All right, just give me one moment, please. All right, Mr. Garcia, are you able to have your witnesses for tomorrow?
Let me speak to him, Judge.
Okay.
Maybe we can have them on standby there. I think they're still in agreement.
Okay, all right, then let me send you with the witnesses. I'll send you to breakout room number 2, and if you could ask your witnesses to go to number 2 as well, please. And everyone, you should be receiving a request to go to breakout room number 2. Who are the parties who are here for this case?
Probation.
All right. Okay, I'm going to send you to number 2.
I'm here.
Okay, let me just find you on the screen. All right, he's requesting you to go to number 2. So if you could all go to number 2, please. And Myrna Alcantara, if you can go to 2. Attorney Lacey, are you a part of this hearing?
Your Honor, I represent Myrna in the CPS case.
Okay.
So I
all
was
right.
here to observe.
All right, I'll send you to number 2 as well.
Okay, thank you.
You're welcome. And Judy Yan, I'll send you to number 2 as well. And Marina, I'll send you to number 2. Yes.
Okay, thank you.
And Samantha Kassan, I'll send you to number 2 as well. Is she a part of this, Marina? I think so.
Yes, thank you.
All right, you're welcome. And who is Caroline Hill? If you could go to breakout room number 2, please, Ms. Hill. Caroline Hill, please go to breakout room number 2.
Yes, Patrick Hale.
It's listed as Caroline Hill on the screen. So Mr. Hill, could you please go to breakout room number 2?
Yes, ma'am.
All right, everyone, we are done for today. We will be back tomorrow at 9 a.m. Bye.